That's an avalanche of evidence. Over 400 PDFs and nearly 100 videos. In legal terms, this is called discovery, the process where the prosecution must hand over everything they have. The defense needs time to sift through every bite because even one overlooked file could change the entire case.
Juan Alberto Martinez. All right. Hi. So on this case, do you have all of the discovery?
Judge, I got handed a hard drive last week that had 431 PDF files, 98 videos, and 94 images. That was the requested discovery that had asked for back on July the 8th.
Yes.
Okay, so I have not yet had a chance to review all those videos.
And I appreciate the fact that you said, I will turn over a hard drive later in the day, back in July, and you did it. Sometimes people will say, I have the hard drive now, so I appreciate that. So how much time are you asking for to review that?
Judge, 30 days if the court would allow it.
All right, Ms. Ferguson, I need a 30-day reset.
And Your Honor, also, I've already filed motions on this case.
Right, just 1 second. Excuse me, sir. Here's the thing. Do you want your attorney to go without having reviewed anything? What he has to review is a lot for him to review. If you want your attorney to go to court blind and be surprised by whatever the state presents, we can do that. But you're not his only client. So the fact that he has all of that to review, he needs to review it to be effective for you. You may continue.
Judge, I filed 17 motions this week on this case. One is a motion to suppress. The other is a motion to reduce bond. And at the court's schedule, I'd like to schedule that as early as possible.
All right. So, State.
Yes, Judge.
With regards to the motion for the bond reduction, have you had a chance to review that, and would you be ready to proceed on that?
Not seen that, but if I look at it, Judge, I can be prepared for it.
All right. So we may be able to take up the motion for the bond reduction today. The motion to suppress, I know the state is not going to be ready for that because I'm assuming there will be witnesses needed.
Absolutely, Judge. The judge will need, the state's going to need at least a week, I think, to get ready for the motion to suppress.
Because I'm assuming it's not just a search warrant where I can read it and say yay or nay. So we're going to come back on September 29th. Is that good for you?
That's good, Judge.
All right. And then state on September 29th, if you haven't done so, you'll need to be able to tender offer on that day. And an acknowledgement of discovery will be need to sign on that day. All right. So if y'all have a seat and if you'll confer with them on the bond, the court will hear the bond matter.
Thank you, sir.
Thank you, Your Honor.
You're welcome. All right. The court is calling 2025 CR 004887. State versus Juan Alberto Martinez. Could I have parties announced for the record?
Jason Garahan for the state, Your Honor.
Robert Featherston representing Mr. Martinez.
And you are Mr. Martinez? All right. Your attorney has filed a motion for bond reduction. State, have you had a chance to review the motion?
Yes, Your Honor.
And do you waive notice?
Yes, Your Honor.
All right. So according to this, your client is charged with manufacturing, delivery, controlled substance penalty group 1.
Whoa, over 400 grams. In Texas, that's not just a felony. It's a first-degree felony. We're talking potential sentences that can rival violent crimes. No wonder the defense is pushing hard for a bond reduction.
Let me see. Is it over 400 grams?
That is correct, Your Honor.
Over 400 grams. The bond is currently set at $25,000, according to your motion, and you're asking for the bond to be reduced?
That's correct, Your Honor.
All right. Do you have any witnesses?
No witnesses other than Mr. Martinez.
All right. Could you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right. You can lower your hand. State your name for the record.
Juan Alberto Martinez.
All right. Counsel, you may proceed.
Thank you, Your Honor. Mr. Martinez, you have a great concern about a family member. Who is that?
This is where the law collides with raw humanity. Alberto isn't just a defendant. He's a son desperate to be with his mother. Judges hear stories every day, but when family illness comes into play, it can tug at the court's discretion in powerful ways.
My mother was just diagnosed with cancer a week ago. and Mr. Featherston has been doing a lot for me. But my case has been turned over from DA to DA to DA. I'm innocent of this charge, but I'm pleading to the court in any way that you all can help me. I mean, I'm willing to do anything you would say, but I am my mom's oldest son. She doesn't deserve to die alone. But I am innocent of this charge. But I would plead no contest to the court. Whatever, if somehow I can get probation, whatever stipulation you can put, whatever.
All
I
right,
would
so
have-
this is
oh,
not,
No, but I'm
the
just
time
stating
for
that I have,
equalization.
that's the problem with my mother. She got cancer. That's what he's stating, my mom.
Your Honor, if it pleases the court, he's under a great deal of stress because of this issue with his mom. He originally started with the PR bond, and then his bonding agency asked for a bond increase as a result of some issues associated with his bond. I think the state will probably go into more detail on that. But we're respectfully requesting that the court reconsider a PR bond for him. There is no violence involved in this particular case. And he would like to be able to provide some assistance to his mom. I'll pass it with you.
right, you may proceed.
I don't really have any questions in this particular case.
All right, so, does he have any funds?
Judge, I'm appointed to his case. He is indigent. And I do not think that he has any funds that he can draw on, considering what has now happened to his mom, which was his sole source of income prior. I don't think that she's going to be able to come up with any money in order to be able to get him out on a bond. He has no bank accounts, no personal property, no real property to rely upon in order to get anything other than the bond.
All right. So what I'm going to do then, because you're saying there's no amount of bond he can make, he needs a PR bond. Is that correct?
Yes, sir.
All right. So in this case, Ms. Ferguson, have him evaluated for a PR bond. And once the evaluation is complete, we'll have him brought back. It shouldn't take that long.
Your Honor, you're most kind, and I thank the court.
All right. So Norm, I want him evaluated for a PR bond. And then we'll place him back on the docket as soon as that completed. It should be done by next week, hopefully.
Not a
And
problem,
then-
Judge. I'm here every day.
All right. Thank you.
Thank you.
Ade? All right. Yes.
I believe you had a discovery setting. The very first initial setting was a discovery setting. At that setting, we got a offer from the state that was a timely. We conveyed that offer. I believe we have received all discovery. I've tendered a discovery acknowledgement to the courts, and I believe the client wanted to address the court, but he formally rejects the offer.
Rejecting a plea deal is a massive gamble. What would you do? Take a guaranteed sentence or roll the dice at trial where the stakes are sky high? Drop your thoughts in the comments.
All right. So do you want a jury trial or a bench trial?
Man, look, I feel like I'm being coerced into signing for something that.
Now, here's the thing. Let me explain the process to you. And I want you to hear me and internalize what I'm saying. So anytime somebody is charged with a criminal offense, once it works its way to the DA's office, they'll review it. They may take it to the grand jury. Once a grand jury indicts a case, which doesn't mean anything, it doesn't mean you're guilty. It's just telling what you're charged with. It gets assigned to a court. And then you get assigned an attorney, and you're probably assigned an attorney before it's even indicted. Then your attorney will make sure that they have all of the discovery. So what is the discovery? The discovery is usually everything that the state says they have in order to prove that you committed this offense beyond a reasonable doubt. That's the way they look at it. That's the way they say, yep, we have enough evidence. In this court, I take it a step further. Once your attorney has told me that they've received all of the discovery, I make sure that the state tenders an offer. Now, the state's offer can be whatever they think whatever they want it to be. They're supposed to be seeking justice. That's what it says in the code. So whatever they offer you, that's what they're offering you. Your attorney will present that offer to you. You can say, I'm not accepting that, which is called a rejection. Or either you can say, I want to accept this, but I will accept this. and then that's called a counter offer. Your attorney is ethically required to give that counter offer to the state, and the state can either say, nope, we're not doing that. The only thing we're offering you is what we previously offered you. Then you have a choice to make. Your choice is either you're going to accept that offer, or either you're going to go to trial or not. Either you're going to do a jury trial or a bench trial. So railroading, whatever you feel railroading is, if you feel railroading is the state is not making an offer that you find acceptable, then to you that's railroading. But they make their offer, and then once they make their offer, you have choices to make. So if you want a jury trial, and this court will give you a jury trial. If you want a bench trial.
Here's a mini law school moment. A bench trial means the judge alone decides guilt or innocence, while a jury trial hands that power to 12 strangers. Each option has its pros and cons. Strategy is everything.
A lot of people think that they get to determine, yeah, I want a bench trial, therefore I get one. But the state has to agree also and say, it's okay for you to have a bench trial. What a bench trial is that I or the judge who's sitting here, we're here, whatever evidence is presented, and make a decision on whether you're guilty or not guilty. Jury trial, there'll be 12 people sitting in the box, 12 random people, right? They'll sit in the box. The state will present their evidence to that jury, or either to the court if it's a bench trial. They'll do that by calling witnesses. Witnesses will come and testify. Hypothetically and normally, this is what usually happens. The state has to prove that it happened in Bexar County, because if it didn't happen in Bexar County, then I don't have any jurisdiction. They usually have to prove an on or about date, and they do on or about dates, so you'll know we're talking about on or about this date. This is when we're saying it happened. If it's a robbery, guess what? Complainant will come in and complainant will say, certain items of value were taken from me without my consent, which means I didn't give this person permission to take my things. This person took my things. And usually a robbery involves some type of physical force. You know, if somebody is walking around with a purse and you snatch their purse, maybe that's a theft of a person, but it could potentially also be a robbery. It just depends on the way it's charged. So that's what the state has approved if it's a robbery case. If it were a drug case, they would have to bring in a chemist to say, yes, these are drugs and these are illegal substances. And then somebody would have to prove that you're the person who possessed the drugs or had care, custody, and control of it. So that's where we are. So if you are not going to come to an agreement with the state, then your next setting is going to be a jury trial date. And you will be brought over dressed in whatever clothing you have at the jail. If you wish to be brought in any other civilian clothing other than what you have at the jail, you'll need to sign a release so clothing can be brought to you. So do you want a jury trial or a bench trial, or are you reaching an agreement with the state?
The reason why I don't want to take what the state is offering me because it's I don't think prison is.
Here's the thing.
The judge's blunt reality check is spot on. Everyone believes their case is unique, but the system doesn't bend on feelings. It bends on facts and leverage.
Let me just tell you, whatever the state is offering you, I'm not involved in what their offer is. But what I can tell you is, if you look over in that box, I guarantee you nobody in that box will raise their hand and say that they think prison is right for them. I've had people, when I was a defense attorney and when I was a prosecutor, they would be charged with murder. They'd be like, prison's not the place for me. Nobody thinks prison is the place for them. You may once every 200 cases have somebody who'll say, yeah, I deserve to go to prison for this. But normally people don't say that. So I don't need to hear about your negotiations with the state, because ethically, I'm not supposed to hear about that.
They're not even trying to hear me. He's not even trying to hear me. That's why I wanted to dismiss.
Okay, so state. Who's the state on this case? With Jacob?
I conferred with Jason.
All right, Jason. All right, Mr. Andrade is informing the court that he wants a dismissal. Are you going to dismiss this case?
No, I'm not saying to dismiss the case.
All right, so he wants something other than what you're offering him. Are you intending to offer something other than what you've already offered?
Is this the case that we discussed? Okay, yes, something. But after conferring, no, Judge, that's the offer.
All right, so he's saying he's not going to change the offer that he has made.
In fact, Judge, just sorry to interrupt you.
No,
Judge.
no.
That would be today only offer since
All
would
right,
be
And
changing.
that's how I feel in track. Like,
all right.
I feel like I got an ultimatum. I feel like if I hire another lawyer, I have a better chance to, get a drug program, because the whole reason why I'm not running from what I did. I
wouldn't speak further about don't admit any guilt. Just please don't say something. Your Honor, we were here on a prior setting earlier this week. He had some time to think about this. I know Jason is leaving.
So today is the day you make your decision. If you don't want to accept the offer, then it's going to jury trial or either bench trial. So you can sit in the box, and then I'll bring you back up at 10:30, and you need to let the court know whether you're accepting, if you've reached an agreement, or whether you're going to jury trial. Those are your options. All right, Jacob Andrade?
Yes, Your Honor.
Yes.
Mr. Andrade had time to think for you. He reobserving his position that the dismissal is not for the case. The dismissal is for counsel to be dismissed.
Okay.
He wants a new attorney, and we would just have this go to a jury docket.
All right, Ms. Ferguson, I need a jury trial date. How long do you expect this trial to last, counsel?
Oh, that one.
And just like that, the path is set. No plea, no shortcuts. This case is heading for a jury trial. The stakes? Potential decades in prison versus the slim chance of walking free. The next hearing could decide everything.
3 days, Judge. I mean,
All right, Norma, 3 days. And it's criminal trial division. And counsel, if you make sure I have an acknowledgement of discovery. I think I may have one, but just double check.
That was tendered on Tuesday.
Okay. All right, October 28th. All right, thank you.